Welcome back to Canadian Justice, where we are discussing a recent decision from the Supreme Court of Canada in the Bissonnette case about the stacking of parole eligibility periods and whether life in prison for multiple sentences really, if you can get out after you've served the first of those sentences. So, Sarah, one of the concerns that I have seen raised by victims groups is that when parole eligibility for the first sentence comes up, the victims' families attend those hearings. They make arguments against granting parole. And now this creates a burden on the families to relive the trauma and the grief of the murder of their loved ones and face that killer at these hearings. So if parole eligibility was stacked, that wouldn't be necessary. Do you have anything to say about that?
Sure. I mean, of course, there's always concerns about the re-victimization of victims. And in this case, a family member would be considered to be a victim where the person is deceased and not able to advocate for themselves. That being said, any victim's participation in the parole board process is voluntary. They have a right to the information, they have a right to attend, they have a right to make a statement in whichever medium they choose to do it in. But again, it is voluntary. And so I think it's important for people to keep that in mind and to also consider maybe where their boundaries or comfort zone lies if they are considering, say, adding themselves to a victim list if they're eligible to do so.
David, is there anything you want to add to that?
Yeah, I would say that part of it is that the judgment itself seems to downplay that perhaps there's value in making a normative condemnation of particularly heinous, hate-filled or murder sprees, such
Which
as we see.
this was one, right? This was a racially motivated, religiously motivated mass murder at a mosque.
Yeah. So that's the other part for concern for the victims is why not just have that normative condemnation and spare us the trouble of having to apply to keep someone in there. I can see that concern, yes.
David, parole eligibility, though, still means eligibility, right? Life can still mean life. Just because someone's eligible for parole at 25 years doesn't mean they'll get it. It could be denied. For example, if the convicted person is a dangerous offender. What's taken into account when someone is considered for parole? What could it take for it to be granted or denied?
Okay, so there is a provisions in the Corrections Conditional Release Act, and there's objectives, which include rehabilitation, reintegration, and all the rest of it. But that provision is also very clear that protecting the public from risk of harm is the key objective. So when someone actually does apply for parole, they really got to make a good sale that they're not going to be a risk if they're paroled. And I know the parole board sometimes gets flack for letting someone out that the public thinks they shouldn't have released. But my own observation is that in the great volume of cases, it can be a really hard sell. The parole board really has to be satisfied that there's next to no risk before granting parole.
Sarah, same question. Anything to add there? For example, what do you think the likelihood is that a killer as notorious as Alexander Bissonnette, whose crimes were so egregious and hate-fueled, what's the likelihood of a person like that receiving parole after 25 years?
Yeah, and I definitely echo David's sentiment there, in that just because you're eligible to apply for parole, it doesn't mean that you're going to be granted parole. The parole board is able to take a huge volume of information and evidence into account when they're considering whether or not it's appropriate to grant parole. Of course, one of the paramount considerations is the person's risk of reoffending and the protection of the community, but they'll have a lot of information at their disposal. They will have the person's criminal background, any interaction with the court system they've had in the past, information from mental health workers, correctional authorities, victims' families. There's a lot of relevant considerations that go into this. It's certainly not a flippant decision.
Yeah, certainly. And there are a lot of notorious killers in Canada. I think people, their mind would probably jump to someone like Paul Bernardo, for example, who's deemed a dangerous offender, has not been eligible for parole. So it's entirely possible that while Mr. Bissonnette could be eligible for parole at 25 years, that he may not, in fact, be granted it. But as you've all laid out, that is up to the parole hearing, something that the families may be participating in.